Hi there, folks. Sam Price here. Welcome to another episode of Probate Notes. And I have with me today a dear friend. Her name is Jennifer Felton. Hi there, Jennifer. How are you today?
Hey, Sam. Nice to see you.
Good to see you as well. And thank you for being on today's podcast.
Thanks for having me.
Absolutely. I just wanted to get started to get a little bit to know you and hear a little bit about you and your background.
Sounds good. So in my first life, I did transactional real estate.
Which life are you in now?
Yeah,
This is the first one.
I am
Which version?
working on three,
Okay, you're Jennifer 3.0 now. Okay.
pretty much.
Yeah.
Um, but in my first life, I was an escrow officer. So I did transactional real estate for about 15 years. And during that time, I went back and became a lawyer. And now I've been practicing for about 16 years as an attorney, focused on the real estate space. So that's my current core profession and job. And then 3.0 is my retirement plan.
Okay, yeah, gotcha. Well, you were an escrow officer. Did you have an independent escrow or did you work for a larger escrow?
I I worked both for title company escrow and for independent. So where I'm at, I live in Ventura County. For the most part, title company escrow is the norm here in Ventura County. But when I went to law school, I was working in Los Angeles, and in LA, it's almost all independent. So I worked for an independent when I was in law school and that part of my career.
And so at what point did you think about becoming an attorney?
Yeah. So anybody who knows real estate and escrow knows it's a really challenging job. Um, the job of escrow is to collect all the paperwork and the documents and the money relative to the transaction. So you're a hub for getting the deal done. And you don't control all of that stuff, but you're responsible for all that stuff. So you're like herding cats, right?
Oh,
Constantly collecting information and documentation. And sometimes it's not in your control, getting something from someone else, but you're responsible. So if it's not done, you're the bad guy, even though you may not be the problem.
times, let's say the property did go to the son and the daughter. And sometimes there are times when more than one person, co-owners, own a piece of real estate that are related, but
Right.
sometimes they don't want to own the property together because I find that no one wants to own half a house that they don't live in.
Right.
They want their money.
Yeah. Well, this is what I see most of the time. Generally, the cases where I see siblings fighting over inherited property, there's three or four siblings, right? And mom was taking care of one of the kids, right? One of the kids was living with mom, and the other three are launched adults
Yeah.
who don't like that sibling,
One is
who
in the nest, three are
that
outside of the
think
nest.
that mom that has been taking advantage of mom, right? And so the two or three siblings who are out are ready to sell, but that one who's been living there thinks he should still get to, or she should still get to live there for free. And
Yeah.
that their siblings are responsible for taking care of them like mom was,
Yeah.
right? And so we get hired often by those siblings to file a court action to force the sale of the property. And that court action is called a partition action, right? So we'll be in court filing a complaint, asking for the court to sell the property or divide the property, and split that asset for the benefit of the beneficiaries.
And so there's a partition action. Is that typically filed in civil court?
It is. It's a civil court action, so it's not a probate court action.
Does the person that lived there have any defense to a partition action?
Their ownership percentage is what they have, right? So let's use a four sibling example, right? So that sibling who's living there, inherited 1/4 of the estate. So they have a claim to 1/4 of the property. So if the siblings under current California law, if the siblings sue that that sibling for a partition action, that sibling has first right of refusal to buy the house. So that sibling could stay, but he'd have to buy out his three other siblings their 75% fair market value based upon an appraisal. Okay. So generally, that sibling who's been riding on mom's coattails isn't in a financial position
Right.
to afford to buy out their siblings to stay in the property, right? So generally it ends up being sold. Um, and they get a piece of the profit, but they don't get to keep the property.
What happens in a partition action if he's not able to buy the property?
Yeah, so a partition action is very hard to defend from a practical standpoint. The law very much favors the rights of property owners, including the right to sell. So they will not force the other siblings to continue to co that property with the brother. They will, if it is physically dividable, maybe mom owned a quadruplex, you
Oh,
know,
okay.
and he could keep his unit, right? Like there partitions you can literally physically divide the property if that's possible, right? But absent some sort of physical division, then the court's going to sell the property if he can't buy it. And he'll just get his portion of the proceeds.
But what if he's really obstructionist and doesn't want to participate in all these kinds of things? Does the court have some type of mechanism to have someone to have the power to sell the property?
Yes. So partition action is a very high. So Um, in the law, our law in the US is based on English common law, which had two components to it. It had the legal component, which was the king, and it had the equity component, which was the church, right? So a partition action is based upon equity and what was the rights of the church within society. So it's like Solomon dividing the baby. I mean, honestly, it's that same analysis. So what's fair, what's right is what the judge's guiding light is. But the law on partition gives the judge the right to issue an injunction. The judge could evict under a partition, not a separate cause of action. Within just a partition action, they can appoint a receiver, they can do an injunction, they can order someone out of the property. They have very broad discretion to handle that asset.
There was a case that you and I had once talked about where you had a husband and wife and that they had gotten a divorce.
Mhm.
Their marriage was dissolved
Yep.
and they owned a property together and they were agreeing to stay on title as joint tenants. Can you tell me a little bit about what happened in that case?
Yeah. So again, a lot of times people put all kinds of interesting deals together
Sure.
relative to their property. So in this particular case, mom and dad got divorced. Mom stayed in the property. Dad was still on the mortgage. That just happens all the time, right? In divorce situations, the spouse who gets the property often doesn't have enough money or good credit, whatever, to get the loan refied. So the old spouse is still on the loan, right? And so, if they're good, honorable people, it's not the end of the world. But if they're not, right, like you can destroy your ex spouse's credit. Yeah,
Oh man,
right,
that's kind of
right.
messed up.
It does. It
Yeah.
happens. Right? So in this case, mom and dad were still on the loan. Mom was living in the property and paying, right? But they had agreed that they would stay on title as joint tenants. It was an amicable divorce, right? And so if and when one of them passed away, the other would get the property. And so they hadn't distributed, right? Like if generally in a divorce, if a property gets kept, then you distribute the proceeds between, right? You buy out the spouse. So they didn't do any of that. They just agreed whoever survives gets it, right? And so that's what they agreed to, but mom, got it in her head that she should go get a trust. And so she went into a doc prep service and they prepared a trust, and they recorded a deed transferring her half of the house into this trust. Well, the problem is that as soon as that deed transferred the property into the trust, it severed the joint tenancy.
Yeah.
So joint tenancy is something that is this right of co-owners to inherit without probate the property, but there's four equities that have to be involved, and the trust and that transfer severed the joint tenancy.